Well, good afternoon, everybody, and welcome to this Landmark Chambers webinar on charging orders and enforcement, this being the fourth in our Nuts and Bolts seminar series. My name is David Nicholls, and I'm your host for this afternoon's webinar, and I'm joined by my colleagues, Evie Barden, Brooke, Lyne, and Joel Semakula. So let us begin. And I have to say, this is a really important topic for all practitioners to understand. I think it's one thing as a lawyer to know the law, to be able to advise your clients on the merits of their case. But it doesn't really matter how good a client's case may be. All clients want to know one thing: am I going to get the money at the end of the day? And this is where a good working knowledge of charging orders and enforcement is essential. And I'm delighted to be able to introduce our three excellent speakers this afternoon. Our first speaker will be Joel Semakula, who will be speaking about charging orders. Joel was my first ever pupil in 2020. Pupillage was going very well until the pandemic started, when I made him move into a room at the other end of the corridor to avoid potential contamination. But fortunately, this did not affect his training, and we welcomed him as a member of Chambers later that year. He now practices in all three main areas of Chambers work: property planning and public law. He regularly advises tenants and landlords, commercial and residential, and has appeared before a range of tribunals and court. And most relevantly for today's talk, he recently secured an order for sale of a residential property to enforce a substantial judgment debt. And I think that may have been one of my cases, in fact, but I'm sure we will hear more about that in due course. The second speaker is Evie Barden, who will speak on priorities. Evie was brave enough to join Chambers in the middle of the pandemic, so I had the pleasure of meeting her remotely for the first several months before eventually I could meet her in person. She also has a successful practice spanning the full range of commercial chancery and property litigation, with particular strengths in property cases involving insolvency, company or commercial elements. She's acted on a number of those cases in the County Court and High Court, and she's also on the Attorney General's C panel. And I'm told she particularly loves land registration and has particular expertise in relation to priorities, so we're looking forward to hearing from her. And finally, Brooke Lyne will be speaking about orders for sale. Brooke is a specialist property barrister with a practice covering real estate matters and commercial and residential landlord and tenant disputes. And she is fresh from the Supreme Court, having recently appeared there, led by Simon Allison in these chambers, acting for the successful landlord in the case of Aviva Investments, Ground Rent GP and Williams. And she frequently advises and acts in matters relating to enforcement using charging orders and orders for sale. And we look forward to hearing from her. But first now I hand over to Joel, who will be speaking about charging orders.
Good evening, everybody, and thank you, David, for that introduction. I had decided I was actually not going to bring up my COVID pupillage trauma on this in this webinar, but since David brought it up, I think it's a fair game. And indeed, that order for sale case it was a case from David, so I'm looking forward to discussing some of that today. In terms of what we're going to be going over, I'm looking at charging orders. So we'll start with the general principles, take you through how the court determines whether or not it's going to grant an order, and then hopefully give you a number of tips on how to deal with the procedure and some of the issues that tend to come up, particularly for junior practitioners there. We'll start firstly with what is a charging order. So we've got there the definition from the report of the Committee on the Enforcement of Judgment Debts. What we're looking at, a charging order is a court order sought by a judgment creditor. It's a means of indirect execution of a judgment debt. And when a charging order is obtained, it charges assets of the judgment debtor, such as land or securities, to the extent of the judgment debt, including interest and cost. It should be noted that it is a slow method of enforcement, and so indeed, the underlying judgment order in the claim I recently dealt with was from the claim actually started in 2015, and that order was only granted at the end of November 2022. But effectively, it's enforceable as a general electable charge over the land. And in general, we're talking about 3 stages. First, the interim charging order, then the final charging order, and then when it comes to enforcement, the actual order for sale, which is what Brooke will be looking at. In terms of sources of law, 2 main sources of law being the Charging Orders Act of 1979, which sets out the substantive law, and then Part 73 of the CPR for the procedural law. At this stage, I also want to mention the practice direction that accompanies Part 73, PD 73, and the Land Registry Practice Guide 76, which does provide some helpful guidance for solicitors and other conveyancers when looking at charging orders. So let's start with section 1. Now, the court's power to make a charging order over judgment debtor's property derives from section 1.1 of the 1979 Act. Effectively, charging orders are available to secure a sum payable under a judgment or an order, including an order for costs. And the important thing is which have been assessed. The amount charged is the amount which the creditor is owed under the terms of the judgment, plus any accrued interest and costs. It's important to note that the definition there in section 1.1 does not include an unascertained sum, an order to pay costs which have not been assessed, a compensation order made in criminal proceedings, or an order against the Crown. But there are some other things there that it does include, and that's subject to other statutes. And you'll see there the Industrial Tribunal awards pursuant to the Employment Tribunals Act 96, an award for repayment to the Secretary of State for Social Security, and the relevant act is given there, fines and other penalties imposed by magistrates, and arbitral awards pursuant to the 1996 Act. And when advising clients, I think it's important for all of us to remember that the existence of a charging order does not mean the creditor can obtain their judgment sum immediately. What they're going to need is take further steps to obtain an order for sale and hope that that sale will actually release the sufficient funds. But what it can do is safeguard, or it may safeguard or secure those funds for the future. What can be charged? Here we go to section 2, and it's really any interest held by the debtor or beneficiary may be charged in the assets as set out in section 2 of the 1917 Act. Those assets are land and various types of securities, and you find a full definition there provided, a full list there provided within that Act. One of the key parts, and something which I'm going to spend some time here, is the court's discretion. Now, when you make an application to the court for a charging order, it's important to note that what they have is a discretion as to whether or not to grant that order. And that's both at the interim stage and then again at the final stage. Now, in exercising its discretion, the court must take into account all the relevant circumstances, whether they arose before or after the interim order, if we're at the final order stage. And the court should exercise its discretion equitably, having regard to the interests of all parties involved, and that includes other unsecured creditors, as well as the interests of the judgment creditor and the judgment debtor. The fact there may be other unsecured creditors is a relevant factor, but the fact they exist does not necessarily mean that the applicant will not obtain the charging order. Other relevant factors include the size of the debt. And in practice, what we find is the courts take a different attitude to the granting of a charging order, which of itself merely gives security from the making of an order for sale. One particular issue that sometimes arises is that a court may possibly decline a charging order at the interim stage if it considers that the application is disproportionate to the amount of the debt. And what you see is that in practice, courts may be minded to grant interim charging orders more easily and consider fully the exercise of their discretion at the hearing of the application for the final charging order, if there is indeed a hearing, a matter I'm going to come on to shortly. One of the relevant factors is the personal circumstances of the debtor. Now, Section 1.5 of the 1979 Act requires the court to take into account these circumstances in considering whether to make the charging order. However, financial hardship to the judgment debtor on its own is unlikely to be sufficient to prevent a final charging order being ordered. But where that order is being sought over a matrimonial or family home, that will often carry more weight, since then it's not just the debtor's interests that are affected. But it should be important to realize that this fact alone will not usually defeat an application for a final charging order. And what you sometimes see, for example, is where you've got a family home, one way a court may do justice is to make the charging order subject to a condition that it's not to be enforced before a certain date, which may be, for example, before the family's able to secure another property or before a child's finished with exams, for example. And the final point there on the slide is the court can take into account the hardship that will be suffered by the judgment creditor if the charging order is not granted. Now, in the case I recently dealt with, I was dealing with a creditor who was in his late 70s. And so there was some concern in terms of just how long he'd been taken for him to be able to enforce against this debt, that he should be able to get his money as soon as possible. We said that was a hardship that was relevant in terms as to why we should, and that was really at the order for sale stage, but it was also something that came up when we were making applications for the original charging orders. Insolvency. Now, if we're talking about companies, the liquidation of a company, whether by resolution or order for compulsory winding up, and the bankruptcy of an individual brings into operation a statutory scheme for dealing with the company's or the individual's assets. And accordingly, if a winding up or a bankruptcy occurs before the final order, this is generally on its own sufficient cause to justify a refusal to make absolute a final charging order over those assets. The judgment creditor can retain the benefit of a charging order only if the final order was made before the presentation of the petition. However, creditor can ask the court to make an interim order and list the date for consideration of a final order after the date of the hearing of the bankruptcy petition. The interim order would be discharged if the debtor is adjudged bankrupt, but can be made final if the petition were dismissed. If the creditor is aware of the presentation of a winding up or a bankruptcy petition, it is under a duty to bring the existence of other creditors to the attention of the court. And that comes from the practice direction, paragraph 1.2, subsection 5. Now, any attempt to get a charging order that's obtained in ignorance of, say, any kind of interim bankruptcy order is liable to be set aside. So it's something that we should be very careful about if we know there may be underlying insolvency proceedings, some are going on in the background. I'll put the Human Rights Act point here, but I imagine this is going to be more of an issue when we hear Brooke's talk. But ultimately, the court should consider any issue raised that enforcement using the charging order mechanism is contrary to the Human Rights Act. Now, generally, I think this is probably less likely to be an issue at the charging order stage, but more likely to see it to be an issue at the final enforcement phase. Now, when is a charging order appropriate? Usually when we're talking about enforcement, when we're advising our clients, it's important for us to be aware the charging order and any subsequent order for sale method of enforcement can be used in addition to other methods of enforcement, either simultaneously or sequentially. Where more than one method is used, the creditor should ensure that they notify and write in the court and enforcement agent of any payment received. And that's actually from PD 70. When we're thinking about whether we should seek a charging order, there are probably a few things we really want to consider. The first is whether the judgment debt has actually become due and is enforceable. We should look at the state of the judgment debtor's resources. And we should also consider whether there are going to be any potential objectors. Now, these may be unsecured creditors, these may be other people who live in the home, anybody else who may object, save for the debtor. Now, really, the charging orders are the most effective method of enforcement when there is substantial equity in the land and the judgment debtor is the sole owner. But like I've said, look, it is a slow method through to enforcement, and it's quite useful where what the debtor has is assets that are quite illiquid, and where we've tried other forms of execution, or where we've considered other forms of execution, but they would not recover the debt. If there are significant prior charges, or if the debtor has no beneficial interest in the property, then this probably isn't the route that we want to go down. I've listed there, I won't take us through some of the key advantages of the charging order regime, while we might indeed go for this route. The key things, one thing is priority, which Evie will be talking to us about. And of course, security. And And the final point there that's really important is that we can normally get an interim charging order without notice, which can prevent the debtor from disposing of his property, which is really important for the matter of security. Moving on now to procedure. What I'll do is I'll take each of these steps in turn. So we'll start with the application, then we'll go to the making of the interim order, and then the making of the final order. The appropriate court. Now, the jurisdiction of the High Court and the County Court to make charging orders is set out in Section 1(2) of the 1979 Act. Now, under that section, the County Court has concurrent jurisdiction to make a charging order in relation to High Court judgments, except where the property to be charged is a fund in the High Court. Where the judgment concerned is a County Court judgment, the application for a charging order must be made in the County Court. Now, where the judgment is for less than £5 grand, the application must be made in the County Court. But if the application is made to the High Court and if that application is made in the High Court in respect of a judgment that's less than £5,000, that application will be dismissed, which will end up taking more time, or will be transferred to the County Court, which we really want to avoid. And that comes from the King's Bench Guide. Generally, what you're going to see is applications made to the County Court, and those must be made to the County Court Money Claims Centre. It's one brief drafting point. In those application documents, the court should be described as the County Court Money Claims Centre. Although I think what we've seen is that sometimes people make mistakes and say put a local county court. In those circumstances, it usually will still make its way to the CCMC, who will deal with the application. Now, we're going to go through some of these, but if for whatever reason those cases are transferred out of the CCMC to another court, any further forms should reflect the transfer by using the name of the local county court to which has been transferred, and it shouldn't remain in the CCMC. You shouldn't continue to list the CCMC as the relevant court. Now move on to the application notice. In terms of what we need to lodge at court, you need to lodge the application form and the application fee. There are two forms, but I'm just going to focus here on form N379, which is if the application relates to land. There's no need to file an affidavit or a witness statement. The information supporting the application just simply needs to be included on the application notice, and that needs to be verified by a statement of truth. In addition to what's on what you can see there on the slide, it's really important that the application contains any further information that the judgment creditor wishes the court to take into account. This form requires full and frank disclosure, as I've said already, of any other known creditors and any other interested parties, which include beneficial co-owners, trustees, and persons with rights of occupation. If any of these details are incomplete or inaccurately recorded within the application, then there's a strong chance the application may be refused. I've set out there some tips for the application. The key thing is it's quite important there to attach a copy of the judgment or the order. It is possible to apply for a single charging order in respect of multiple judgments against the same debtor. And you can also apply in one application notice for charging orders over more than one asset. However, if you're dealing with more than one asset, the court will draw up a separate order relating to each asset, and that's set out in the practice direction. You should set out as much detail as possible, and you should also attach the office copy entries to the application. Any detail you have as to the beneficial interest should be included. And remember, what the court's being asked here to do is to exercise the discretion, and there is a chance that you may get objections prior to that order being made final. So make full use of the section there, the further information section on that form. The key thing is to build the strongest case possible by saying out any information which would justify the court making this order. And I've set out some examples there on the slide. I'll take us now through the stages of the interim charging order through to the final charging order. Now, applications made to the CCMC will be initially dealt with without a hearing and without notice to the judgment debtor. Save for certain exceptions, where the application concerns the judgment debtor's interest in land, it will be considered by a court officer. So it's largely an administrative process. He or she will have a checklist of prescribed criteria, and if these are met, he or she may make the interim charging order. And when we get to the final order, charging order stage, that will normally be made by a district judge or a deputy district judge. What we found anecdotally is that in making those applications to the CCMC, they're generally coming back with interim charging orders within about a month. And like we said on the slide there, it's pretty high success rate. A party may request that a decision by a court officer be reconsidered by a district judge, and that request for reconsideration must be filed within 14 days after the party is served with notice of the decision. And it appears that that request may just be made in writing by letter. There's no prescribed form, and that reconsideration will also take place without a hearing. And in that letter, you should just include that party making the request should include the reasons why a reconsideration is being sought. Now, if the court makes an interim charging order, the effect is that a charge is imposed over the judgment debtor's interest in the asset or the asset to which the application relates. The order and the application document should be served on various people, and the charge may have to be registered to be effective. And I've got the details there, and you'll get the slides afterwards as to how that service needs to take place. But it's important to know that if the judgment creditor fails to comply and fails to apply for an extension of time within the period specified, the matter must then be referred to a judge who will consider whether to dismiss the application and discharge the interim charging order. Now, that first slide was in respect of where the order is made in the CCMC. Where the order is made in other courts, where the application is made in the other courts, a hearing is normally fixed to consider whether a final charging order should be made. And I think it's important to note that date carefully. The hearing will be at least 21 days after the date of the interim charging order. And in that case, the judgment creditor must either file a certificate of service in relation to each person served not less than 2 days before the hearing, or produce a certificate of service at the hearing. There on the slide, you'll find the people who must be served with a copy of an interim charging order if it is made. And those people also have to be served with the application notice and any documents filed in support of it. So that includes the order, any office copy entries, any judgments, and that must occur within 21 days of the date of the interim charging order. And CPR 73.7 also has provisions regarding applications for extensions of time for service and what happens if service is not undertaken as required. So it's just really important to refer back to the CPR for what needs to happen there. Spoken a little bit about the effect, but if once you've served the interim charging order, the legal effect of service in respect of land is that if the land is jointly owned, the charging order would only apply to the debtor's beneficial interest, but a subsequent sale of the property to realize the money to pay the judgment debt could still take place. Now, service of the charge on the co-owners puts them on notice of this and allows them to raise objections at the hearing of the application for a final charging order, or in the hearing of any later application for an order for sale. It's important to note that a sale to a bona fide purchaser without notice will defeat the charge if it's unregistered. I think if you leave with anything today, is that in order for a charge to be effective, it must be registered. I think Evie will go into slightly more detail here in terms of registration here and the options, but effectively, if the land is registered land, the charging order can be protected by either a notice or a restriction on the land register. An important point to know is that the fact there's a restriction usually doesn't prevent a sale going through. And if you have two charging orders, for example, you've got charges against different assets, you will need two notices or two restrictions. So if you've got two judgment debts against the same debtor, this might be a reason, for example, to ask the court to issue just one charging order. And the point there is whether you go for a notice or restriction usually depends as to whether the judgment debtor is a co-owner of the property sought to be charged. There is normally further consideration in CCMC cases. In CCMC cases, an interim charge order would not automatically require a hearing date for it to be made final. However, anyone who has been served and who objects to the application has 28 days from service to file and serve on the judgment creditor written evidence stating the grounds of objection. Now, if an objection has been received, then the matter will be referred to a district judge, and the matter will probably be transferred to the debtor's home court. But if there's no objection to the final charging order within the 28-day period, and there will be no need for a hearing, then the application for the interim charging order to be made final will be considered by a judge or a legal advisor. If no objection is received, then provided that procedure has been complied with, you're going to get your final charging order. And if the whole thing remains unopposed, which it often is, then the entire process simply remains at the CCMC. I've put some tips there for objections, but I'm going to slightly go ahead in light of time, just talk about the final charging order. When we get to the final charging order, the court may make a final charging order subject to conditions such as the charge shouldn't be enforced provided the debtor pays the debt by specified installments, or the charge shouldn't be enforced until after a certain date, for example, in the case of a family home. And in exercising its discretion to make a final charging order, the court should take into account all the circumstances, whether they arose before or after the making of the ICO. The point is the court needs to do equity so far as possible to all the various parties involved, that being the judgment creditor, the debtor, and other unsecured creditors. In terms of costs, now it should be noted that the costs on obtaining a charging order are fixed costs, and that's given in Part 45. But if you consider your case an unusual one or deserving of more than fixed costs, then you should obtain a court order for other than the fixed costs. And the court will usually also allow reasonable disbursements. It's also important to know that if the judgment creditor has incurred costs as a result of the intervention from other parties, they should seek a separate costs order in respect of those costs which fall outside of the fixed costs regime. And the final point I want to make on costs is that a successful objector may ask for their costs at any hearing. It is possible for a charging order to be discharged, and that may occur at any time on the application of the debtor or any other interested person. And that's Section 3.5 of the 1979 Act. The court there has a discretion, again, which is not to be exercised lightly, because a balance needs to be struck here between the interests of the party whose property is charged and the holder of the charge. The relevant procedure is set out there at CPR 73.10b, and then there are also some rules there as to who that discharge order needs to be served on. And then the final point here, just going on to the conclusions, the key things I want to draw out here are that what we have here, it's essentially a county court remedy, but it is discretionary. Although there's a high success rate for obtaining interim charging orders, a client should be advised that there is no guarantee of obtaining a final charging order. There are cost risks of obtaining an interim charging order on a dubious basis. And there's also little point of incurring costs objecting to an order being made final unless there are good grounds for objecting. And as will be made by Brooke, simply having a final charging order does not mean that a sale of the property is imminent. The application form is very important, and that's your opportunity as the applicant to set out as much information for the court as possible. What we find is that strong applications can often deter speculative objectors. Thank you very much. Back to you, David.
Okay, hello everybody. I think it's over to me, and hopefully my talk leads on very neatly from what Joel's just been talking about, because if you've been through all of the hoops just discussed to get your charging order, that of course doesn't give your client necessarily the remedy that they really seek, because actually what they want is their money, and the main way to get their money is to obtain an order for sale. So starting from the very beginning, what is an order for sale? So it's exactly what it says on the tin, exactly what you think it is. It's the court ordering that a property must be sold and setting out the circumstances and the logistics of how that will happen. There are kind of two key scenarios. where you might get an order for sale, and they're the scenarios I'm going to be talking about today. The first is an order for sale as a consequence of a charging order, as Joel's just talked about. And I'm also going to touch on orders for sale under Talata, so where there's a trust of land and you're seeking an order for sale. They're the two main routes, and that's what we're going to be talking about today. Why would you want an order for sale? So as discussed, you'd want to enforce a charging order. That's how you get paid. And of course, you don't have to enforce your charging order. You can just sit on it, you can wait. You don't have to obtain an order for sale. There's no obligation to do so. You could just sit there and wait for interest to accrue. And in certain circumstances, that might be an advisable thing to do. And it is really important to ask the third question when advising your clients: is this the right time? Should we be seeking an order for sale? The bottom line is that there's absolutely no point trying to get one if there's going to be insufficient equity, or in fact no equity in the property to settle the debt. If there's not going to be the money, there's little point. It also might be specific as to the market conditions. So if house prices are having a dip in a particular area, or in the area where the property is located, it might not be the right time to apply for an order for sale. Similarly, taking sort of a topical example from the last few years, if the property that is the subject of the charging order is a leasehold property, perhaps in a block that's had cladding or fire safety issues, such that the property is of a much lower value than it was before, then again, it might not be the best time to apply for the property to be sold. It might be better to wait until issues relating to building safety works and the costs of those works have been sorted out before applying for an order for sale. So please make sure you ask that question right at the very beginning before you go down the line of applying for an order for sale. Okay. Jurisdiction, and I'm only going to touch on this briefly. Jurisdiction comes from the Charging Order Act 1979 that we've already looked at. Where the debtor is the sole legal and beneficial owner, jurisdiction arises from the statutory engagement of the court's inherent equitable jurisdiction. And then you'll see there I've put the provisions from the CPR that gives the court the power to make a charging order and then make an order for sale. In co-beneficial owner cases, we also have jurisdiction coming from the Trust of Land and Appointment of Trustees Act 1996. So it's section 14 of Talata, and that's where the court may make an order for sale of a legal estate upon application from any person who is a trustee of land or has interest in the property subject to the Trust of Land. So as I say, charging order, if there's a charging order, you may well be able to apply for an order for sale. Equally, if the property is subject to a trust, then you may well be able to use section 14 to apply for an order for sale without needing a charging order. There's just the power under section 14 to do that. The next key thing to point out is that charging orders, in the same way that charging orders are discretionary, orders for sale are also discretionary. And if you've already got through the gateways of applying for a charging order, you might think, well, we've already satisfied the court that we are entitled to a final charging order. Surely we've covered that off. That is not the case. When you're dealing with an order for sale, you are essentially asking the court to sometimes grant an order for sale over someone's home, or indeed a valuable asset. And the focus that the court will place on an order for sale is likely to be much stronger than it would have focused on at the charging order stage. There's a very clear warning in the notes to the White Book in CPR 7310C, and I've set that out on the slide, and that is a very clear warning that it is treated as a draconian step, and the courts treat orders for sale as a remedy of last resort. Anyone that does possession claims or possession work will know that judges don't like evicting people, and if they can find a way to avoid doing that, judges often will. Often that may well be the scenario when you're seeking an order for sale. So it really is a remedy of last resort, and you do need to think about other enforcement options before you go down this route. Assuming you do want to go down that route, there are going to be a whole range of factors to consider. Firstly, the welfare of those in the property. That's always going to be a key consideration. If you're dealing with a family home, that's going to be a harder application than if you're dealing with commercial property or uninhabited property, or property that's not a family home. So I put on the slides there reference to a case from 2009. That was a jointly owned property, jointly owned by Mr. Brent and Ms. Pallett. They lived in the property together. There were 2 charging orders that were obtained against Mr. Brent. The debts were entirely his debts. Both of the joint owners had health conditions, and the judge considered that Mr. Brent's attitude had been continually refusing to comply with court orders and continually refusing to pay his debts. And despite being sympathetic to Miss Pallett's condition, because the debts were not hers and she had extenuating circumstances of her own, that did not stop the court granting the order for sale, and an order for sale was granted. So even when there are significant welfare issues, the court may nonetheless still grant an order for sale. And that same question about welfare of those in the property still applies if you're dealing with a sole owner, sole beneficial owner case. So even if the only person who's in the property is the person who is the debtor, that question of their welfare is still relevant. Just because they are the sole person who's responsible for the debt doesn't mean that their welfare gets sort of shoved to the side. It's still going to be a relevant consideration. As Joel alluded to earlier, Article 8 and human rights arguments may well arise, and you do need to give those some thought. And there may be situations or particular cases where the court needs to carry out a proper proportionality assessment. And the case on that is a case from 2010 called NatWest and Rushmer. And if you have got a scenario where an objector is raising Article 8 arguments, you do need to give that careful consideration. Some other factors: attitude of the debtor. The case I talked about earlier, Mr. Brent's attitude in repeatedly just refusing to pay his debts, even in circumstances where he could pay them, was a really important consideration for the court. If the debtor is able to volunteer, so the prospects of the debt being paid without an order for sale is also going to be crucial. If a debtor turns up to court at the hearing for an order for sale and says, look, I've got a proposal as to how I'm going to pay this debt off, or how I'm going to pay it off over time, then that is going to be one of the most convincing ways to prevent an order for sale. If the court can be reassured that this debt will be paid, then that's a successful way, or a very promising way of defeating an application for an order for sale. On the other side of things, for the person applying for the order for sale, that's why you need to show that you've thought about other options. Have you thought about an order for an attachment of earnings if the debtor is someone that's employed? Have you thought about other ways of getting your money rather than just going straight for an order for sale? Because if the debtor then raises these other options and says that they're willing to pursue these other options or to engage with these other options, then you may well find that your application doesn't succeed. Of course, someone objecting will need to provide evidence, and often you find with these hearings, a debtor might attend as a litigant in person and may not have actually provided any evidence to support their contentions. And you do, if you're acting for the person applying for the order, need to remind the court that proper evidence needs to be before it. And if you're the person acting for the debtor, you're going to need to explain why these debts are still outstanding and what can be done to address them going forward. Another factor will be whether the sale would be unlikely to raise sufficient funds to settle or significantly reduce the debt. So if, as I pointed out at the beginning, this property is in negative equity, or there's so little equity in it that it's not going to be worth the hassle, then that's going to be a pretty important consideration. And the case that I've put on the slides there, Amari Lifestyle from 2017, was a case where the property that was over which an order for sale was sought was the subject of a discretionary trust and subject to an equitable charge to secure a proportion of the sale proceeds for the trust. And if an order for sale had been made, the trustees were likely to enforce their security, which would mean that there would be insufficient funds to pay the applicant anything. So when one delved into what would happen upon sale, it became clear that actually an order for sale wouldn't significantly reduce the debt. In fact, there mightn't be any money available at all. So an order for sale would be pointless. The next factor, and this is a factor that there's, that can go either way, is the ratio of debt to the value of the charged asset. And here, the case I've referred to is the Pacman local case from 2010, and it says there's no rules or presumptions. And that was a case where the debt was £200,000, but the property to be sold was worth around 16 million. And the claimant had sought an order for sale over that property, but the court concluded that an order for sale would not have been inappropriate in the circumstances, notwithstanding the apparent disparity between the debt and the value of the property. So here, the fact that the debt was really small in comparison to the value of the property was not decisive, albeit a relevant factor. The ratio point is a double-edged sword, because obviously if the debt is small and the property is worth a lot, then the court may say, well, it's disproportionate to an order for sale to take place. But if you're dealing with a situation where, well, this person owns a really valuable property here, raises the question, well, why haven't they discharged this debt? So it can go one way or the other, and do think carefully about how you frame the arguments about the ratio of debt to value. Another relevant factor, and can be quite a decisive factor, is the attitude of other secured creditors. And if they are supportive, that's going to be really helpful to your application. If other secured creditors write to you saying, no, we don't want you to do this, then that's going to be quite important information for the court when deciding whether or not to make the order for sale. Okay, moving on briefly to later cases. So where, rather than dealing with a charging order and an order for sale pursuant to a charging order, we're dealing with a Section 14 application for an order for sale where there's a trust of land. There are specific factors set out in Section 15 of Talata, and I've put them up on the slides. Many of these replicate the things I've just talked about, that are the general discretionary factors that the court will have regard to when deciding whether or not to make an order for sale anyway. Intentions of the persons who created the trust is a new one. If there is a trust document setting out the parties' intentions, then that's going to be a relevant consideration. Purposes for which the property is held on trust, again, relevant consideration. Welfare of any minor, that would be relevant in an ordinary case anyway. If there are children in the property, their welfare is going to be a pretty important consideration for the court. Interests of other secured creditors, and then the circumstances and wishes of any beneficiaries of full age and entitled to an interest in possession. So again, an additional factor, but those beneficiaries might have been able to object in an ordinary case anyway. Even in these cases under Section 14, the rights of a creditor remain a powerful consideration. That comes from a case from 2001 called Mortgage Corp and Share. And then another important case, the interests of families will not necessarily outweigh those of creditors. Again, a helpful case if you're dealing with a family home type scenario and you still want to obtain an order for sale. So that's a very quick run through of all the things the court will consider, but ultimately it is a discretion and you can never be certain what a court's going to do. It will depend on the type of judge you've got, how that judge is feeling on the particular day in which you're seeking to make your application. So if there's another takeaway that I can add as a takeaway that you must not forget from today, it's that you need to be very clear that there's significant litigation risk with these applications. They're never a slam dunk, and that needs to be made very clear to your clients. Just touching on this briefly, there are regulations from 2013 dealing with regulated agreements. Those regs came into force in 2013. So if you're dealing with a charging order that has been made to secure a payment under a regulated agreement, and that is an agreement that comes within the Consumer Credit Act 1974, no orders for sale can be made to recover an amount that's for less than £1,000. I don't think these regulations are particularly important, given that rarely would one advise a client to apply for an order for sale for less than £1,000 anyway. It seems too small a sum to be asking someone to for an order for sale in respect of. So these regulations, as far as I'm concerned, are pretty useless and feeble, but important to be aware of them just for completeness. Okay, moving on to the procedural points then. I've put on the slides two key provisions in CPR about which court. So in a claim for an order for sale should be made to the court where the charging order was made, unless that court doesn't have jurisdiction. So if the court that made the charging order, you should apply to the same court that made the charging order unless that court doesn't have jurisdiction. And where the charging order was made in the CCMC, as Joel was talking about earlier, the majority of those charging order applications are now made by the County Court Money Claims Centre, then it needs to be, the order for sale application needs to be made to the judgment debtor's home court. There used to be a really, really good tool on justice.gov to find your local county court or your home court. That tool has been changed in recent years. It now makes it quite a bit harder, and you actually just have to put in the postcode and you'll get a variety of courts that are nearby, and it's actually not nearly as useful as it used to be, but you do need to find out what the home court for the property is and make your application there. Which court, the county court or the high court? Now, for the majority of cases, the county court is going to be the right place to go, and as we usually say, if you can go to the county court and get it, don't apply in the high court, because the reality is the high court will often bounce them back to the county court, which might incur costs, or indeed it might result in significant delays. But there are financial thresholds. So where the judgment debt is no more than £350,000, the county court can deal with it. If the judgment debt exceeds £350,000, then you need to go to the high court. And crucially, this is about the value of the judgment debt, not the value of the property. So you can go to the county court and ask for an order for sale over a £10 million property, as long as the debt is no more than £350,000. And I think there's often some confusion about those limits, but important to bear them in mind. I'd say that usually you should go to the Chancery Division of the High Court if you're seeking an order for sale, and there's a case that suggests that that's probably the right place to go. Other thing to point out is if you exceed that financial threshold, so if it's a case where the judgment debt is more than £350,000, make sure you tell the High Court in your covering letter that that is the case. Because I was hearing about a case recently where the High Court transferred the claim back to the county court for the order for sale, but actually the financial limit was exceeded and the county court didn't have jurisdiction to grant the order for sale. But the High Court couldn't see that immediately on the face of the order of the application, and as a consequence it went back to the county court, and then solicitors had to apply for it to be sent back to the High Court, and inevitably that caused lots of time and delay. So please make it clear if you are in excess of the financial threshold. Procedure, I'm going to canter through this quite quickly. You need to initiate new proceedings. You can't bounce off the back of the previous charging order proceedings or the previous proceedings in which the debt was ordered. It's a new claim, and it's a new claim using a Part 8 claim form and using the Part 8 procedure. There are prescribed forms, the N208 form, please use it. If you use something else, then you run the risk of the court saying, what is this? I don't know what this is. Delay, confusion, you might have to start again. You also need to put in a copy of the charging order with the claim form and your supporting documentation, because this is a Part 8 claim in the usual way. You need to list the defendants, the debtor, any other known adult occupiers of the property if you're seeking a possession order as part of the order for sale. You also need to list as defendants co-beneficial owners or other legal owners, so that everybody that ought to be heard should be. Other interested persons, such as other secure creditors ought to be notified about the claim, but they don't need to be defendants or parties to it unless they make an application to be joined. On the slides, I've set out what the prescribed written evidence needed is. I'm not going to go through it here. So it's paragraph 4.3 and then over to the slides. The key point I just want to point out here is paragraph 4.4. The claimant must take all reasonable steps to obtain the information that is above. So that's the obligation to be discharged, all reasonable steps. There may be some things that your client cannot obtain, and they just need to take all reasonable steps to obtain it. These are the things, this is going into a bit more detail about that evidence. Identify the charging order and properties to be sold. That'll be covered off in the witness statement. The amount in respect of which the charge was imposed and the amount due at the date of the issue of the claim. That needs to be done carefully, calculating what the judgment interest is, both on the principal debt and any costs. So you've got an accurate figure of what the judgment debt is now. Verify, as far as you know, the debtor's title to the property. It might be that the title documents from Land Registry are sufficient. If the land's unregistered, it's going to be more difficult. You're going to need title deeds and you're going to have to try and find them. Further evidence about beneficial interest. So if there is a trust deed, that will be helpful. This can be really tricky as the party who may not know very much about this particular property and the debtor may not be inclined to provide you with this information. You have to be a bit creative about trying to get it. Name of other creditors, give an estimate of the price which could be obtained on sale. This could be done by sort of a drive-by valuation from an estate agent. You're going to need to give that information to the court because the court will need to set a minimum threshold for the sale. Details of persons in possession of the property, that's going to be relevant to the discretion of the court. And then if there's a Class F land charge, so you need to carry out a proper search by if it's registered land on using form HR3, that's a particular process to go through. And then if it's unregistered land, using an office search at the Land Charges Department. Okay, touching briefly on the order, most orders are conditional or suspended. And the reason for that is that the court likes to give the debtor one final opportunity to satisfy the debt before the property is sold. The order will also usually make provision for it to be sold for a sum no less than specified amount. In my experience of obtaining these orders, be realistic about what that sum is. Don't go into the court asking for a value that's significantly below what could reasonably be achieved, because the court will be very unhappy at that. The court will want to protect and ensure that the property is sold for a market value. So make sure you've got valuation, a drive-by valuation or evidence of what the likely value is going to be. And if you find that you've got an order and actually you can't realistically sell it for that after the order is granted and you've tried, you can apply back to reduce that figure. The courts don't like making an order that's too low because then they're concerned that it might be sold for an undervalue. Okay. The order should make provision for the practical aspects of the sale. So sometimes the order might say who the conveyancing solicitors will be. Some judges are quite happy for that to be the solicitors who are acting for the claimant in the application for an order for sale. Sometimes they will want another set of conveyancing solicitors to be appointed. There will normally be a possession order requiring occupiers to leave before a specified date, and other provisions about what and how the proceeds will be applied. And in a moment, Evie will talk to you about priorities. And then it will also deal with creditors' entitlement to costs. Helpfully, there are two precedent orders in Practice Direction 73 in the annex. So worth looking at those when you're thinking of making one of these applications. They're not prescribed forms, they can be varied and adapted as needed, but they are kind of the forms that the court tends to use, so helpful to take a look at them. One final point I just wanted to touch on, and there's no space to go into it in any detail, but should be in the back of your minds, is the recent regulations for breathing space and mental health crisis moratoriums. A creditor cannot take steps, these regulations provide that a creditor cannot take steps in respect of a debt unless permission is given by the court, when there is a breathing space moratorium or a mental health crisis moratorium in place. And I've put on the slides there 2 cases in the last year, obviously the same parties involved, where there was a moratorium in place, and those cases give us some guidance on how these regulations will be applied. So if you find out that there is a moratorium in place, you need to think very carefully about whether you need to go and get the court's permission before you can take steps to enforce a debt. And on that final note, I will hand over to Evie.
Thank you very much, Brooke. I'm going to talk about priorities. As Brooke just alluded to, the value in a charging order, much like any charge over land really, may be very greatly impacted by the priority that it has over other interests in the land. For example, if there are multiple charges and there's insufficient equity available in the property, it will matter very considerably what order the charging order ranks in for purposes of payment out of the proceeds of sale if an order for sale is obtained. Similarly, if there is a person who alleges that they have a beneficial interest in the property, you and your client will need to think how that may impact on your client's ability to enforce the charge. So it's critical, therefore, to have regard to the general rules on priority. And on the screen, I've set out the Charging Orders Act 1979, and in specific section 3, subsection 2, which says that the Land Charges Act 1972 and the Land Registration Act 2002 shall apply in relation to charging orders as they apply in relation to other orders or writs issued and made for the purposes of enforcing judgments. And subsection 4, subject to the provisions of the Act, a charge imposed by a charging order has the same effect and is enforceable in the way that an equitable charge created by the debtor by writing underhand. So the question of whether the charging order has priority is not impacted by the 1979 Act. For the rules on priority, you have to look elsewhere. On this screen, you, if you're like me, will hopefully recognise this image as being from Formula One. If you're a fan of the recent or long-standing, actually, TV show Drive to Survive, you'll see a battle there between Lewis Hamilton and Max Verstappen. And the reason this is relevant, or at least tangentially for the purposes of priorities, is under the general law, the first in time has priority where equities are equal. Those rules, or that rule, is modified by 3 possible statutory, three additional things that you need to think about. The first is unregistered land, where you have a charge of unregistered land and it's registered under the Land Charges Act 1972. It will rank according to the date of its registration as a land charge. Section 2, subsection 4, little Roman 3, means that a general equitable charge of a legal estate is a Class C land charge. A equitable charge of an interest under a trust, however, cannot be registered. A chargee of an equitable interest will have priority under the rule in Deer and Hall, which is that, broadly speaking, the person who gives notice first to the trustees of the land gets priority. But note, and it's probably relatively unimportant given the prevalence of registered land, but note that that doesn't apply to a charging order because of the case of United Bank of Kuwait and Sahib, which says that a charging order, the person with the benefit of a charging order is a volunteer. What about registered land? Is that modified by the Land Registration Act? Well, first, you need to look at the basic rule in section 28, which provides, except as provided by sections 29 and 30, the priority of an interest affecting a registered estate or charge is not affected by a disposition of the estate or charge. And subsection 2, it makes no difference for the purposes of this section whether the interest or disposition is registered. So the basic rule also means that the order of creation is critical. Drawing that all together, in general terms, where there's unregistered land, subject to exceptions, the interests rank in the order of time. And one of those exceptions is charges registered under the Land Charges Act. Where you have registered land and there are unregistered interests, as between those unregistered interests, they will rank according to the basic rule in section 28, i.e. first in time. As section 28 alludes, though, that's not the end of the matter. You need to look to sections 29 and 30 of the Land Registration Act. Section 29 is set out on this slide, and section 30 is in very similar terms. That applies to registrable dispositions of registered charges rather than a registrable disposition of a registered estate. What is a registrable disposition of a registered charge or registered estate? Well, a registered charge by section 132 is a charge the title to which is entered on the register, and a charge is any mortgage, charge or lien for securing money or money's worth. A registered estate is a legal estate, the title to which is entered in the register other than a registered charge. What dispositions are registrable is set out in section 27 of the Land Registration Act. I don't propose to take you through that all now, and you'll need to look at that, but in very high terms, it's things like transfers of property, the grant of a lease for more than 7 years, the grant of a legal charge, transfer of a registered charge, the grant of a subcharge. So when you have an event like that which occurs and it is registered, and the registered estate is made for valuable consideration, completion by registration has the effect of postponing to the interest under the disposition any interest affecting the estate immediately before the disposition whose priority is not registered. An interest is protected, however, if either it is subject to a notice in the register or it falls within any of the paragraphs in Schedule 3. And I'm not, again, going to take you through that in detail, but probably the most important one, it's interests which override registrable dispositions, and probably the big one to think about is an interest of a person in actual occupation. And then lastly, if the burden, if it appears to be accepted from the effect of registration. What about registered charges and registered mortgages? Is there anything you need to look to determine their priority? Well, that comes from section 48 of the 2002 Act. Registered charges on the same registered estate, so legal estate, or on the same registered charge are to be taken to rank between them in the order shown on the register. And pursuant to the provision in subsection 2, there are rules in the Land Registration Rules 2003. You need to look at Rule 101, which provides, subject to any entry in the individual register to the contrary, for the purpose of section 48(1), the order in which the registered charges are entered in an individual register shows the order in which the registered charges rank between themselves. Joel has already addressed this, so I'm not going to go through it in any real detail, but critically remember what I said earlier, which is this is not a charging order is not a legal charge, it's an equitable charge. So it's not a registrable disposition for the purposes of section 27. When you're thinking about the nature of a charging order, it can be one of two things. It can either be an equitable estate over a legal interest. So, for example, where you've got a sole proprietor or all the proprietors are debtors, you'll have a charging order that charges the legal estate. And in that situation, the charge can be protected by a notice. Section 32 of the Land Registration Act says that a notice is an entry in the register in respect of the burden of an interest affecting a registered estate. And then we go back to the definition of the registered estate as being a legal estate or charge. And the second category of thing that an equitable charge, a charging order could be, is an equitable charge over an equitable interest in land. So if the property is held on trust, then, and you get a charging order over one of the co-owners or the beneficiary share, then you've got an equitable charge over a beneficial share in the property that is held on a trust. In that situation, only a restriction would be permitted, and you get that from section 33 of the Land Registration Act, because that precludes a notice being entered in the register in respect of any interest arising under a trust of land. The standard restriction that you get is a standard form K restriction, which is in the following words: no disposition of the registered estate other than a disposition by the proprietor of any registered estate, registered charge registered before the entry of this restriction is to be registered without a certificate signed by the applicant for registration or their conveyancer that written notice of the disposition was to be given to the creditor at insert an address, being the person with the benefit of an interim or final charging order on the beneficial interest of judgment debtor's name. I know that David and Joel have pretty strong views on the efficacy of this. That probably itself could give rise to quite considerable discussion. So I don't propose to go into it in any detail now, but you may well, given the terms of that, think about a non-standard restriction, because that's not really particularly very helpful. Now, I think the best way to really get into how the rules on priorities work, and probably the most interesting way, is to discuss scenarios. So I'm sorry, but you're all going to have to participate in a quiz with me, which I've very inventively called Who Wants to Have Priority? So if you go to, that is the first answer. If you go to the poll in your Zoom interface, you will see the first question, hopefully, on the screen. Clara or Josh, can you access that for me, please? Because I can't seem to. Okay, great. So I'm sorry, I personally can't see the poll.
I can see Evie.
Oh, okay. Great, I can see it now, sorry. So the question is, you've got a registered proprietor and creditor goes and obtains a charging order over the property. They don't then register notice on the title. The registered proprietor dies. The registered proprietor's personal representatives transfer the land by assent, that should say assent, I'm sorry, to the second registered proprietor, who is then registered. Does the second registered proprietor take subject to the charging order? And we've got a pretty split audience tonight, 43% saying yes, and well, 57 now saying no. It's sort of going up and down. the answer is unless the personal representatives discharge the charge first, the second registered proprietor will take subject to the charge. And why is that? Because there's no consideration for the purposes of section 29 of the Land Registration Act. And as you will recall, section 29 of the Land Registration Act provides that it only operates where you have registrable dispositions of a registered estate for valuable consideration. Now, this was quite clearly not, there was clearly no consideration, but you do need to be mindful of the absence of a clear definition of valuable consideration. Section 132 of the Land Registration Act says that it can't include marriage consideration or nominal consideration, but it doesn't go any further than that. So, there is scope for that being arguable in an appropriate case. So in order for R2 to take free, the personal representatives would need to discharge the charge prior to transfer. So the majority of you clearly thought this the right answer on this one. What about scenario 2, which is on the screen? You've got a creditor who obtains a charging order and registers a unilateral notice against the property. The P has a person has a beneficial interest in the property which arose prior to the charging order but is not registered. Does the creditor have priority? Oh, again, 50-50. We vacillating around the 50-50 mark. No sort of creeping up now. I think steadily we are getting into no as being the dominant view. This situation is effectively the situation in human solicitors and central stream services, a 2012 Court of Appeal decision. Now, at first instance, Mr. Justice Briggs, as he then was, found a charging order is not created for valuable consideration. So the basic priority rule in section 28 of the Land Registration Act 2002 applies, and the unregistered equitable interest had priority. At Court of Appeal, the point about a charging order not being created for valuable consideration was accepted and not argued as being incorrect. And that's the United Kuwait Bank case that I mentioned earlier. But Human said that on a sale, any purchaser would be bound by their interest and would take free from the equitable interest, but would take free from the equitable interest. And the Court of Appeal held that ignored the company's right to require Humans to remove the UN1, such that they obviously had priority over the charging order. And that's the situation we find ourselves in. So the creditor's interest here will rank behind the beneficiaries. Oh, sorry, I'm not doing very well with the slides, am I? Third scenario now, hopefully, is on your poll. You've got registered proprietors, two registered proprietors who have a property subject to a charging order in the creditor's favour, which is noted on the title by unilateral notice. A purchaser buys the property for £10 and pays the purchase monies to both R1 and R2. The charge is not discharged, is P bound. So yes, flying ahead, we've got 80 plus people, 80+% of people, now 92. Okay, we've got limited time, so I'm going to go through to the answer. You would think at first blush, the purchaser is going to be bound by the creditor's interest because of section 29 of the Land Registration Act. But I'm sorry to have been mean and set up a trick question. because you have to think about Section 2 of the Law of Property Act 1925 here and overreaching. What is overreaching? Well, overreaching is what happens where you have two or more trustees and a trust corporation, and the conveyance, the purchaser pays the purchase monies to those two or more trustees, or applies it at their direction. And Section 2(1) little Roman 2 says the conveyance is capable of being overreached where the requirements of Section 27 are made in respect of the payment of capital money. So basically what happens is that the purchaser, by paying the trustees, that payment overreaches the beneficiary's interest. Critically, you have to look at what purchaser means under the Land Law of Property Act, and Section 205(1) says a purchaser in good faith for valuable consideration will acquire an interest in property, and a purchaser only means a person who acquires an interest or a charge on property for money or money's worth. What about if the purchaser is paying £10? That's the sort of fly in the ointment that I've thrown in there. Does that change things? By Section 29, would that be nominal consideration and mean that the charge first in time, can it be overreached? Well, what is valuable consideration for the purposes of the Law of Property Act? That's defined by Section 205 also, and that says it includes marriage consideration and the formulation of a civil partnership, but does not include nominal consideration in money. Well, query whether £10 is nominal. So in fact, my third bullet point may well not be correct in view of that. If it were overreach, what happens? Well, the creditor's right shifts to the proceeds of sale. I'm not going to go through the case now, but if you want a helpful summary of where you find what a purchaser needs to be, whether a purchaser in good faith needs to make themselves aware of what happens to the beneficiary's interest. The High Court in N3 Living and Burgess Property Investment said overreaching will take place even where the purchaser knows of the existence of the equitable interest and the purchaser isn't concerned with trusts affecting property. That's the point of Section 27 of the LPA. The purchaser is not concerned with the proceeds of sale after they're received by the trustees. That's the question for the trustees. Okay, the fourth problem. You've got a registered proprietor who executes a TR1 to R2. During the registration gap, a creditor obtains a charging order over the property. Does the the purchaser, the person to whom the transfer was made, have priority over C? Huge groundswell of views up for yes. The answer here is before anyone is registered, it's a question of the time the interest was created. So first in time, R2 has priority. My second question on the screen is, does it matter if the creditor registers a UN1 prior to completion of registration for R2? And what is the effect of Section 29 when someone gets on the title? Well, the question is the charging order a registrable disposition? No, because of humans. So the creditor will still take subject to R2's equitable interest in the property. And therefore R2's equitable interest will bind that creditor. Okay, last, a little bit different. You've got three different charges. You've got an interim charge charging order obtained on the 2nd of September, registered on the 5th of September, a mortgage created on the 1st of September, registered on the 10th of September, and an unregistered charge created before all of those and before all of their registration dates. What is the order of priority? Pretty even split between all of the options here. The mortgage has priority over both the interim charging order and the unregistered charge. The registration, the mortgage is a registrable disposition, and registration of the ICO prior to the mortgage does not confer priority, which it did not have. The unregistered charge is not protected on the register and therefore can't operate pursuant to section 29. As between the unregistered charge and the interim charging order, well, again, you've got the humans question. The ICO is not for valuable consideration. And so both only take effect, both the ICO and the unregistered charge being equitable charges. You look at section 28, i.e. the basic priority rule, which was first in time. And therefore you've got the unregistered charge over the ICO. Would it be different if there was no unilateral notice, but only a restriction for the interim charging order? Well, no, for the reasons I've just gone through, but do note that a restriction doesn't confer priority for the purposes of section 29. We're now, I think, going to go on to the Q&A, but just briefly by way of wrap up, I think what comes out of all of those questions is this is very complicated and knotty, and any time you have a question of priorities, you need to go back to the Act, the Land Registration Act, and think very carefully about the dates of creation of the interests, as well as when they were registered, and the nature of those interests. I'm now going to hand back over to David.
Well, thank you very much to all our speakers for their very informative and, dare I say, creative presentations. Clearly a lot of work has gone into preparing those talks, and thank you for that. We do have some time, a very short amount of time, for questions and answers, and we've had a large number of questions coming in, so thank you to the audience for all of your questions. We simply won't be able to get to all of them in the time available. I'm going to kick off with one question, and I'm going to put it to the whole group, but it may be Evie. It's probably a question for you, given your chancery background. And the question is this: it's a comparative question, really. It's looking at the advantages and disadvantages of what we've been talking about today. And somebody asked, given the risks and the costs of going for a charging order, going for an order for sale, it's quite a process to go through that, and there's an exercise of discretion and so on. Isn't it just easier to go for bankruptcy if the debt exceeds the bankruptcy level? So why should somebody go for a charging order and an order for sale? What are the advantages as opposed to just letting somebody else get on with it in the bankruptcy proceedings?
Well, the clear disadvantage with bankruptcy is that it is a collective procedure. Once a bankruptcy order is made, all the unsecured debtors rank equally. That's known as the pari passu rule. So you have the pot of assets that your debtor will have, and those will be distributed equally amongst the unsecured creditors. And that's with a very significant caveat, which is often by the time that there has been a collection of all of those assets, they've all actually been swallowed up in the costs of administering the bankruptcy. So very often there's little, if anything, left over for the unsecured creditors. Whereas if you go and get yourself a charging order, whether you choose to enforce it by obtaining an order for sale or not, what you do is you elevate yourself to the position of a secured creditor. You're not competing with all the other unsecured creditors if there is a bankruptcy order is made. So it seems to me there's a pretty clear advantage just generally, even before you get to thinking about orders for sale, in elevating yourself to that status. But also you're not at the behest of somebody else. Once the bankruptcy order is made, it is down to the trustee as to whether they choose to collect certain assets, and the time frame for doing that is totally outside of your hands. So you firstly may never see any return on your judgment debt, and if you do, who knows when.
Yeah, I think you're absolutely spot on there with that answer, Evie. I don't know, Joel or Brooke, if you have anything you want to add, but I think getting in and putting yourself ahead of other creditors is the absolute key reason why this method of enforcement is so much more attractive than any other. And I think that's a very important takeaway lesson from this evening's seminar. I can see the clock just coming up to 6:30, and I will reiterate my thanks to all our speakers, Joel, Brooke, and Evie. Thank you again for your contributions, and my thanks also to our participants for staying the course through this informative and stimulating webinar. Thank you, everybody.